We're going to talk about the investigative stage of a criminal case. Come with me and I'll tell you some secrets of the do's and don'ts during the investigation. A lot of criminal defendants don't hire attorneys during this investigative stage because they're hoping, by crossing their fingers, that the district attorney won't pick up the case and won't file a case against them. However, it's my opinion that every criminal defendant who's under investigation should take a proactive stance regarding the case. For example, if you're a criminal defendant or a possible defendant who's under investigation, it would be wise to consider hiring an attorney so that attorney may try to convince the police detective or the district attorney not to file criminal charges against you. Can that be done? Of course it can. Let me give you an example of a case from a few years ago. I represented a gentleman who found out that he was being charged with a crime, a serious felony. He contacted me and told me he just wanted to be prepared if he was going to be arrested. What he really wanted me to do was try to arrange bail before he was arrested, because he knew that if he had bail set up, once he was arrested, he wouldn't be sent to jail if the bail bondsman came and bailed him out right away. But I told him there was something else that I might be able to do. I might be able to contact the prosecuting district attorney and try to convince the district attorney that this case should not be filed for many different reasons. For example, there wasn't enough evidence. Number two, the witnesses or the alleged victim wasn't credible and had ulterior motives such as money. Number three, I tried to convince the district attorney not to file because the case was probably going to take a very long time if it went to trial and be very expensive for the county. When the county takes a case to trial and tries to convict you of a crime, it's a very serious and a very expensive matter. There are a lot of fees and costs associated with having a jury trial, and a lot of district attorneys, in my opinion, don't want to prosecute that case which they think they might not win. In that case, from a few years ago, I was able to convince the district attorney not to file because there wasn't sufficient evidence. Now, I'd like to think it was my argument, but the district attorney may have found out other information from the police detective, from the witnesses, that also convinced him or her not to file the case. But you have to take a proactive stance. You have to get in there and find out from the beginning what's going on, what does the police report say, all of that type of stuff, so that you can convince or try to convince the DA not to file a case against your client. Does it always work? No, it doesn't always work. Is it worth the try? Definitely. Because sometimes the defense attorney is able to pick up some information that he or she would not have known had they not tried to contact or been in contact with the district attorney. So in ending, consider talking to an attorney right up front. Consider asking the attorney to try to contact the district attorney to try to find out information or convince the district attorney not to file the case. My next email is going to have a video on the arraignment process. If you have any questions for me, please give me a call at 888-888-6582 or find us on the web at the address below. If you go to the website, there'll be a special report and a book that you can download.
For your free consultation, call the law offices of Vincent W. Davis and Associates today. 1-888-888-6582. That's 1-888-888-6582. Thank you for watching.